discuss amongst yourselves, and then you tell us what you think. If you can look at number 9, this table, Cook Islands, Vanuatu together. You tell us about number 10. You think about it, then we ask you, and if you can look at 11, then we'll ask you whether it's market access, national treatment, or neither nor. Then of course the others, you can look at them, then we'll see if you agree or disagree. And then we'll have specific ones for you to look at. So I give you a minute or two, think about it. There are some that are fairly straightforward. Others are a bit more complicated. So you all have it on your own computer screen? Yeah? Again, the key questions: market access, is it one of the 6? National treatment, does it modify conditions of competition to detriment of foreigners? Be careful, there's some that are not as straightforward, so you have to think about it carefully. Okay, let's try. Let's see. Number 8. Establishment of new pharmacies is only possible through the takeover of an existing pharmacy store. What do you think? This table, you've discussed it a bit more. You agree on something? This one is a bit more difficult, huh? Market access, national treatment, or neither nor, or neither nor. What do you think? Why? So market access, it has to be one of the 6. Is it one of the 6?
One of the 6, so it would go under, is it like C?
Yeah, but how is it a limit, a maximum limit?
Well, is it because there's only a certain number of pharmacies?
Yes, very good. So this one is a bit a hidden one. It's a bit more complicated, but it is a market access limitation because you can never have an additional number of pharmacies. So if you have 100 pharmacies in the country, you'll never have more than 100. So in practice, there is a maximum number of pharmacies. Okay, you can only open or establish a new pharmacy if you buy an existing one. So if there's 100 pharmacies, there's never going to be more than 100. So it's a limit on the total number. So it's the market access. It's not discriminatory, but it's a market access limitation. Hotels, so we move over there. Hotels of above 80 rooms are not allowed to be connected to the public sewage network and must have their own wastewater treatment plant. Neither nor. So Cook Island says neither nor. Vanuatu, the same thing. Yes, neither nor. So it's a requirement that is imposed on foreign-owned hotels, domestic hotels. It can be burdensome. Smaller hotels don't face the requirement of bigger ones. But in the end, there's no market access limitation, and there's no discrimination on basis of nationality of the owner of the hotel. Okay, so good, neither nor. All retail stores must be closed on Sundays. Are they open on Sundays in Solomon's?
No, because
No?
because it only tells only retail stores open, but other stores can other shops.
Yeah, but interesting way of looking at it, but let's go step by step. So again, all measures of government have an impact on some suppliers or somebody. Okay, in one way or another, not everybody is treated equally, but we're only concerned about market access and national treatment. So in this case, all retail stores must be closed on Sundays. Okay? Is it a market access limitation? Is it one of the 6 types of market access limitations? Is it a limitation on the total number of suppliers of retail services? No. There can be 100, there can be 1,000. There's no limit. Is it a limit on the maximum value of transactions in the retail sector? No. You can sell as much as you want, right? Of course, if the opening hours are very short, it has an impact, but it's not a limit on the total value of transactions. It's not a limit on the total number of operations. Of course, you have less days to do business, but it's not a limit on the maximum number of operations. It's not a limit on number of natural persons, type of legal entity, no. Foreign equity limit, no. So it's not market access. Is it national treatment? No. So it discriminates. Maybe retail stores cannot open, but other types of stores, they can. You know, but here what we're concerned about is discrimination between foreign and like domestic supplier. Okay, so all retail stores, foreign and domestic, they all face the same requirements, so it's neither nor. Okay? So it means that it's not a market access limitation. It means all the neither nor means that this is something that is not affected by your schedule. It's not something you need to put in the schedule. It doesn't matter what type of commitment you have. You're allowed to do whatever you want with respect to these types of measures. It's not affected by your commitment. So in this case, neither nor. Next table, hotels owned by foreigners must have at least 100 rooms. There is no minimum required for nationals. Hotels owned by foreigners must have at least 100 rooms. There is no minimum required for nationals. Is it a limitation or no? What does it mean? It means that if I'm a foreign investor, I want to have a hotel, I need to have 100 rooms at least. So it means I cannot have a small hotel, right? I need to have only more than 100 rooms. Local hotel owners can open any type of hotel of 10 rooms, 20 rooms, 50 rooms, and also above 100. So is that a limitation or no? Is foreigners and national receiving the same treatment here? No. The foreigners receive less favorable treatment because they cannot essentially operate smaller hotels. So that's less favorable treatment. So in this case, clearly it's a national treatment limitation. I mean, typically you could say it's in the schedule, typically, and I think you see that for some of your countries, you essentially carve out, you exclude part of the sector, or you reserve part of the sector to nationals only. Small retail stores, foreigners not allowed. Small hotels, foreigners not allowed. So typically in the schedule you will find that in the sector column, countries will exclude from the sector column, from the commitment, part of the sector. So they will exclude small hotels from the commitment. Okay, but it is a limitation. So you could say national treatment. Okay, let's move this down. Nope, the other side. Sorry, the other side. Okay. So next one. Well, let's do them together. Engineers must register with the National Association of Engineers. So if you want to provide engineering services, you need to register with the National Association of Engineers. Neither nor, good. It's not a market access limitation, and in itself, it's not a national treatment limitation. It's not market access either. You simply ask to register, so that's okay. It depends if there are discriminatory requirements when you register, that has to be seen, but in principle, neither nor. Foreign students may be subject to higher tuition fees. It's a trick question. You see, I'm being very nice. I tell you in advance, it's a trick question. I don't tell you what the trick is, but it's a trick question. Foreign students may be subject to higher tuition fees. So you can imagine it's the case like that in many countries, developing. Foreign students that come here, they have to pay higher tuition fees than local students. Foreign patients coming in to receive medical treatment, sometimes they may have to pay higher tuition fees. By law, it might be required. Foreign tourists, sometimes, including in the region, you go to visit something, you pay more. I've done that as a foreign tourist. You pay more than the local tourists. Is that market access? Is it one of the 6? Limit on total number of suppliers of education services? No. Is it a limit on maximum value of transaction in education services? No. Number of operations? No. Foreign capital participation? No. Type of legal entity? No. Is it national treatment? Don't be afraid to be wrong. That allows us to discuss. So there is discrimination because the foreign students, but is it national treatment? What is national treatment? National treatment is, remember, less favorable treatment to who? The foreign what? Huh? The foreign services or foreign service suppliers. Is there discrimination here? Less favorable treatment to the foreign supplier of education services? No. There's a discrimination against the consumer of the service, right? But national treatment is about discrimination towards the supplier or the service. In this case, there is no discrimination. So it's neither nor. So it's a trick question because it seems there is discrimination, but it's not national treatment discrimination. Okay, so a lot of countries have these types of, higher taxes or fees for foreign consumers. That's okay. But when it's not national treatment, it's not something you need to put in your schedule. So what mode of supply is this? Mode 2, very good. For consumption abroad. The foreign student comes in the country to consume services. So actually, this country that receives the foreign students, they're exporting services, right? So if you want to limit your exports of services, you want to tax the foreign consumers that come in, you can do that if you want, but that's not national treatment, okay? National treatment is discrimination against the supplier or against the service. If you were to discriminate against a foreign-owned university, then that's a problem. But if you want to discriminate against consumers, that's something else. Okay? Next one, foreign banks cannot operate more than one branch per region of the country. Is that a limitation? So if your government wants to adopt a new law that says foreign branches cannot operate in more than one region of the country, would you tell them we don't need to worry about this, it's not, our schedule doesn't matter, or it's something we need to look at because it's market access and national treatment limitation? So it is clearly discriminatory because it applies only to foreign banks. So foreign banks cannot, they have a limit, they have an additional requirement, so it is discriminatory, national treatment. They cannot operate more than one branch per region of the country, so it's also market access. So not more than one branch, a maximum number of, in this case, branches per region of the country. Okay, so all this to highlight that even if it's a market access limitation that applies a maximum limit that is only for a region or a part of the country, it is still a market access limitation. Okay, that needs to be reflected in the schedule. So in this case, market access with both, but we only list in market access. Next one. Okay, let's not do all of them because we'll be lacking for time. Let's go down. Let's do 17. Let's do the last three. Purchasing of land by foreign companies and foreign nationals is subject to a reciprocity requirement. That's another trick question. Anybody wants to say what they think about that one? So of course, if you have restrictions on the purchase of land that apply only to foreigners and not to nationals, normally it would be a national treatment limitation. In this case, they say, okay, it's a bit more than that. They say purchase of land by foreign companies and nationals is subject to a reciprocity requirement. So anybody know what a reciprocity requirement can mean here? What is a reciprocity requirement in trade? Some countries used to have that as a condition, in their laws. Reciprocity, what does it mean?
It's the same treatment, like if they are able to purchase the land in a country, so
Yes,
they would be able
very
to do the
good.
same.
Yes, they will reciprocate, or you will reciprocate. So essentially, purchase of land by foreigners is subject to reciprocity, so it's only allowed if the other country, the country of the investor, does the same thing for your investors. If they allow someone to buy land, then you allow them to buy land, for example. Okay, so subject to a reciprocity requirement. Is that inconsistent with anything? To have reciprocity requirements. I allow foreigners only if they allow me to do the same thing. That's inconsistent with one basic obligation of PESA Plus or the GATS. What obligation would that be? So assume I'm in Samoa, I will allow I will allow investors of suppliers of Australia to open up a shop if they allow me to open up a shop in the same sector. New Zealand, I don't allow them because they don't allow me. I allow Australia, I don't allow New Zealand. Sorry? Very good. That's an MFN issue. That's an issue of most favored nation. That's discrimination because you don't give the same treatment to the foreigners, to the different other parties. Okay, so reciprocity requirement is an MFN issue. By definition, it goes against most favored nation treatment, so it's not something you can put in your schedule of commitment. Schedule of commitment is about market access limitation, national treatment limitation. It's not about MFN. You cannot put reciprocity requirements or MFN issues in your schedule. What you have in your schedule of commitments in the GATS is the minimum you give to all WTO members. In your PESA Plus schedule, what the level of market access, national treatment that you specify there is the minimum you give to all PESA Plus parties. Okay? So it's only limitation to market access and national treatment. Okay, so it was a bit of a trick question, but just to come back to MFN. Condition of 1 year previous residency in order to provide legal services. So this one, we can say neither nor for the reciprocity requirement at least. Condition of 1 year previous residency in order to provide legal services. So everybody that wants to provide legal services need to have been a resident of the country for at least 1 year before they can supply the service. So I hear faint national treatment. Yeah, I think I heard that. National treatment, so we saw that example before in the slides. So it is something that on the face of it seems to apply to everybody, but de facto it's something that discriminates against the foreign nationals. So I would say national treatment here. And we end with this one, grants. So in PESA Plus, it's not something you need to put in the schedule because they're excluded, but aside from that, subsidies or grants from the government are available only to national companies and individuals. So with respect to film production, for example. So subsidies given by the government cinematographic office, available only to nationally owned companies, not to foreign owned companies. Market access, national treatment, or neither nor? National treatment, yes. Okay, so you give subsidy only to the locals, not to the foreign owned like company, so that's national treatment. Okay, very good. We go back to the slide, please. Yeah, next one. Okay, so we have seen what market access means, what national treatment means. So we'll need to use that when we look at your own national schedule, because you're the ones who need to ensure that it is complied with, that people understand it within government and also private sector. So you see here the example of a fully completed schedule. Again, we come back to hospital services, and in this case, mode 1 and mode 2 unbound, meaning there's no commitment. Mode 3 national treatment, none, no limitations to national treatment, so we apply full national treatment. And mode 3 only through incorporation with a foreign equity ceiling of 51%. So market access limitations in mode 3 listed here, okay? So it means, what does it mean? It means that with respect to that particular sector, this is the minimum level of access that this country guarantees to all others, party to the agreement, okay? It doesn't take any commitment on modes 1 and 2, so it's free to do whatever it wants, impose any kind of market access restriction to cross-border supply of hospital services, which is hard, or mode 2, consumption abroad, no commitment. So what does it mean? It means it can impose any type of restriction to consumption abroad. So it can prevent its consumers to go, in theory, consume hospital services abroad. Or it can say, well, if you go consume hospital services abroad, we will make you pay an extra fee. Any type of measure inconsistent with market access national treatment is allowed because there's no commitment, okay? Mode 3, you have commitments, no limitations to national treatment, 2 limitations to market access are inscribed, and the rest is fully committed. So the only 2 types of measures inconsistent with market access that can be used are these 2. Incorporation only and no more than 51% foreign equity. So another example, tourism services. So out of the 9 big sector groups, tourism, and then we have in the first column a commitment that is limited to hotels and restaurants, subsector A, and then we have CPC numbers that if you look at it, you will see, for those working on tourism, you will see it includes all types of different accommodation services, hotels, motels, campings, any types of different, many different types of accommodations and of restaurants. So this is the commitment. And then for that service, then we have under mode 1, unbound. So no commitment. Mode 2, which is very important in tourism, no limitations. Okay, so what does it mean again when you have no limitations under mode 2? What does it mean? If in your own schedule you say none, no limitations under mode 2, what does it mean? Mode 2 is when The consumer goes abroad to consume the service. If in your own schedule you say mode 2, no limitations, what does it mean? It doesn't mean that you allow the foreign consumers to come in. No, no. It means that you will not prevent your consumers to go consume abroad. You will not take measures with respect to your consumers when they go and consume abroad. That would result in discrimination against the supplier or the service, or that would be a market access limitation. Of course, it's a much less common now for countries to impose restrictions on mode 2, but it used to be the case where that could happen. Now it's not very common. But mode 3, for hotel services, so this country has a limitation, joint ventures required with foreign majority ownership permitted. So it's a market access limitation, joint venture requirement, one of the 6. And so the fact that this country has put it in its schedule means that it's allowed to have that in place, to apply it, or to introduce it in the future. Okay? But all other types of market access limitation, there is a guarantee that they will not use it or apply it. Okay, so if another party, suppliers from another party have the certainty that, if they want to invest in hotels and restaurants in that sector, they know that this country can impose a joint venture requirement with foreign majority ownership permitted, but they know that there will be no other market access limitation imposed. So they know that there won't be a limitation on number of hotels, maximum number of operations, and so on. The only limitation is this one. With respect to national treatment, so requirement for foreign hotels or joint venture hotels with respect to nationality of employees. And then mode 4, which is movement of natural persons. You will often see that in schedules, unbound, except as indicated in the horizontal section. So we'll talk about the horizontal section in a second. But what is important is that for mode 4, most often countries in regional agreements and also at the WTO, they have used this type of formulation, which is more or less accepted practice. And it is just a very prudent way of indicating what is the commitment. Okay, unbound means no commitment. So it means no commitment except what is indicated in the horizontal section. So I'll show you an example of the horizontal section. But they are very prudent because the scope of what is mode 4 is laid out in general terms in the agreement. Countries can have different views about that, so they want to be very prudent. They don't say what the limitation is. They say no commitment, and then they say what they allow. Okay, so I'll show you an example of that. So horizontal commitment, you all have in your schedule, I think, an horizontal section, or what we call horizontal commitments. And this is at the beginning of the schedule, so it's the first part of the schedule, the first page or two. And essentially, the main purpose of it is to avoid repetition. So it's just for convenience. It's not mandatory to have a horizontal section, it's to avoid repetition. And because you can have some limitations that apply to all sectors. You can have certain limitations that don't apply only to one sector, they apply to all sectors. So the purpose of the horizontal section is to avoid repeating the same limitation for every sector you have in your schedule. So you just list it in the horizontal section, and it is understood to apply to all sectors included in the schedule. Okay? So horizontal commitments or horizontal limitations condition all other entries in the schedule. So when you say for a particular sector, none, no limitation, the horizontal section still applies. So the horizontal limitation still applies on top of that. Okay? So you have here one example of an horizontal commitment or horizontal section. Horizontal, it always applies to the sectors included in the schedule. Okay, other sectors are not committed, so it's not relevant. And then you don't need to list for every mode. You only list if you have limitations that you don't want to repeat every time. So if you have some of those, you can list it there. So in this case, there's nothing on modes 1 and 2 that needs repeated. On mode 3, they say unbound for subsidies, and they say acquisition of land subject to government approval. So I assume this means acquisition of land by foreigners is subject to government approval. So land ownership restriction for foreigners is something that typically will apply across all sectors. It's the same type of discriminatory requirement. So you don't have to repeat it every time for all the sectors in the schedule. Just for convenience, you list it here once, and this applies everywhere in your schedule. Okay? Same thing for subsidy. They say unbound for subsidies, meaning no commitments on subsidies. They're free to discriminate as they want when they grant subsidies. Okay, so these are a good example of horizontal limitations that apply and that condition everything else that is in the schedule unless you say otherwise. Okay? And then this is a good example of a mode 4 commitment in a positive list agreement. So typically the commitments on the natural persons, most of the time it's the same thing for all sectors. There's not a difference with whether it's for legal services or accounting. It's the same commitment. And so typically mode 4 commitments will be governed by the horizontal section, and then they're made to apply to all the sectors committed. But you lay it out, you explain it in detail only once in the horizontal section. So unbound, so no commitment, except for the temporary presence, blah, 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 of these categories of natural persons. And so they will say unbound, no commitment, except for these categories of natural persons. So Richard yesterday mentioned a number of examples of categories of natural persons that are often found in schedules of commitment. Not all countries have the same commitments, but what is most typically found are services salespersons or business visitors. So those are people that come in to negotiate the sale of a service, so to sign the contract for the sale of a service, or to do the paperwork to establish a commercial presence, so business visitors. And then what is more significant is intra-corporate transferees, the most common category of natural persons. So these are natural persons that are transferred from the investor's parent company to the foreign investment it establishes abroad. So if a company from Samoa establishes an office in Tonga, then it may want to transfer from the investor's company, may wish to transfer a manager to oversee the investment in Tonga, the supplier in Tonga. So intra-corporate transferees, then you can have definitions of what this means. You can limit it to different types of employees. And then you can have other types of categories, typically what we discussed yesterday. So natural persons that are independent professionals. So an independent lawyer that is a supplier, and then he moves abroad or she moves abroad to provide the service as a natural person, or a natural person that is employed by a service supplier. That service supplier has a service contract, and to fulfill the contract, a natural person goes temporarily abroad to provide the service. Okay, there can be different categories within the scope of Mode 4, and these are laid out, defined in the horizontal section, and typically the horizontal section will say for each category of natural person the maximum duration of stay. Because we know from the scope of the GATS or that of other agreements that we're talking about temporary movement of persons. But these agreements don't say what temporary is. So in the end, each country will define in its schedule the maximum duration of stay. So for intracorporate transferees, it may be, 3 years. For other categories, it may be 3 months, 6 months. Okay? That is typically specified here in the horizontal section. Or in the case of PACE Plus, it would be in the movement of schedules for movement of natural persons. Okay, but same basic idea. Okay, so I just already mentioned that. We saw all the horizontal limitations condition the sector-specific ones. We saw earlier, so we see for Mode 4 unbound except, and then we list what is committed. And then typically, at the sector-specific level, we would say unbound except as indicated in the horizontal section. So no commitment on hotels for Mode 4, except for these categories of natural persons that we've listed in the horizontal section. Okay, so that's what it means. Additional commitment quickly, but I think that we will see more concrete example when we look at your schedules, and then we can discuss them. The additional commitment is the last column, okay, of the schedule. It's not something that needs to be filled out. You use it if you want to. Most of the times, countries will not use it. The purpose of that is to schedule measures that are not market access limitations, that are not national treatment. Because actually, what is market access, what is national treatment? It's a very small number of measures. There's many laws and regulations and procedures and regulations that affect trade and services. Many. And that's fine. But most of them are not discriminatory, and most of them are not one of the 6. So most of them are neither nor. Okay? But this column of additional commitment allows countries that want to undertake commitments on other matters with respect to these neither nor types of measures. Okay, so one can use this column to undertake additional commitment to bind itself with respect to other types of measures. So it could undertake commitments to be more transparent, to provide answers for responses to those who seek licenses. And so we'll see some examples of that later on. So typically, you will find that in your PACE Plus schedules. Many of you with respect to telecommunication services or maritime transport, for example. So this is just to give you an example, or to show you that schedules of commitments in PACE Plus or GATS can really cater to many different policy intentions. And depending what your policy objective, your policy intention is, then you would express that in different ways in the schedule. So let's take one example here of a country that has, the current situation is that they have a foreign equity ceiling of 49%. So in a given sector, there are no limitations except that they have a maximum foreign equity limit of 49%. That's in their law, okay? Now, depending what your intention is as a government, as a negotiator, then you would indicate different things in the schedule. So if your policy intention, you want to, in a negotiation, you want to retain full discretion. You want to retain discretion to raise this to 100, lower it to 20 or to 0. You want to have full discretion to be more restrictive regarding the foreign equity ceiling. Then what do you say? You say unbound. You take no commitments. If you want to have full discretion to be more restrictive, to lower the foreign equity ceiling to 0, or then you say unbound. Okay, no commitment. If your objective, and this is the most common one in services and negotiations, your objective is to guarantee the status quo. So basically you want to guarantee, you want to bind your existing level of openness. You want to guarantee to other parties that you will not make your current regime more restrictive. Okay, which is most of what people are trying to do in trade agreements on services. So guarantee the existing level of openness, so you give investors, suppliers, the guarantee that it will not be worse in the future. So basically you want to bind, to guarantee that this level of 49% is not going to be more restrictive in the future. So you just list this existing measure and limitation. Foreign capital participation limited to 49%. So you list that in your schedule. So that way everybody knows that the minimum they can have is 49%. You cannot make it more restrictive. That's the minimum you have to give to all other parties. If your policy intention is to liberalize, to get rid of this restriction, to change your law, reform and open up the sector fully, then you would say none. Right? But that would mean that none means full commitment. It means no limitation to market access or national treatment. So you would not be allowed to have this foreign equity ceiling. So you would have to get rid of it to be in conformity with your obligations. Okay? And then you can think of many other scenarios. Sometimes what happens is that countries will actually commit to less openness than they actually are providing in practice. So even though they permit up to 49%, maybe they want to be prudent, they want to keep a margin. For whatever reason, they will commit to a bit less than that. So they will say, well, in the schedule, they will say foreign equity limit, maximum foreign equity limit of 30%. So this is the minimum that you guarantee to everybody else. You guarantee that everybody, all other parties will get at least 30% foreign equity, even though in practice your law allows for more. The guarantee, the legal guarantee that you give through PESA Plus is up to 30%. So this would allow you in the future to bring down the ceiling to 30% in conformity with your commitments. Okay? Well, then there are different scenarios, but just to highlight that, really commitments, you have a lot of flexibility in terms of how you define the sector, how you express the limitations, so that it reflects different types of policy intentions that you may have. Now, just want to recall that the value and the purpose of schedules, whether in the GATS or PESA Plus or other regional trade agreements, the value of schedules of commitment is that they are legally binding. They provide for legal guarantees, minimum guarantees of access. Okay? That said, there are some possible derogations in PESA Plus. Richard mentioned that yesterday. There are some in the framework text of the agreement and the chapter. You have some, well, actually, of the whole agreement, you have some general exceptions. So in the GATS, you also have some general exceptions that allow you to take, for example, necessary measures to protect life and health or public morals and so on. So you have general exceptions to take necessary measures to protect life and health, for example. So these general exceptions, if you have some measures that fit the criteria of the exception, then that can override your commitments if it meets those requirements. Then, as Richard mentioned, there are also exceptions for prudential measures, balance of payments measures that would allow you, if you meet the conditions of the exceptions, that would allow you to derogate from your commitments. Okay? I don't think that would be something very common, but it's something to consider. Now, the GATS and I think other regional trade agreements allow you typically to renegotiate commitments. But typically what happens is that if you want to make your commitments worse, if you want to change your schedule to make it worse, so you want to take a sector out, or you want to, I'm not going to ask you to lift your hand if you want to make your schedule worse, but if you want to make your schedule worse or you want to introduce a new restriction, you can change your schedule. That's possible. Okay? In the WTO also, you can change your GATS schedule. But of course, the value of commitment is that they provide for legal certainty. If you could change it like this from one day to another, it has no value. The value of the commitments, because often they don't actually liberalize, they just provide for legal certainty. They provide guarantees over time. Suppliers know that the market will not be more restrictive in some areas, so they can plan, they can invest. So it's not easy. You can change your commitments and make them worse, but you need to pay compensation. So you need to compensate the other parties or the other members. So in the WTO, for example, how it works is that and that's why countries have not made that often. It's something you can do, but it's something you don't want to do because it's very difficult and for good reason. So if you want to make your commitments worse, you want to withdraw a commitment, you need to compensate the others, you need to notify that you want to do it. Countries that feel would be affected would notify that they feel they would be affected, and then you have to negotiate with them a compensation. Not a monetary compensation, but you have to compensate them with equivalent concessions elsewhere. So basically, if you say, well, we change government, we want to take out, the financial sector from our schedule. So you have to notify, others would say they are affected, and then you have to give them something in return. So it means maybe you have to add more sectors to your schedule or liberalize other parts of your schedule. So it's not something countries want to do. Okay, so it's better to make sure that governments are aware of the commitments so that they have it in their mind when they want to do changes, and they know before they do anything that they need to comply with this. Okay, because it's very difficult. It's doable, but it's difficult. Okay. Now, this is only if you want to make your commitments worse. If you want to improve your schedule, it's very easy. Of course, it's very rare, at least in the WTO, that people want to do that outside of a negotiation. Typically, they want to do that if others do the same, But if countries want to improve the schedule, in some cases that happens. They undertake reforms in a given sector. So, for example, Honduras did that. They undertook They liberalized, they opened up their telecom regime. They wanted others to know that. They wanted to bind themselves, take commitments, bind the reforms they had taken. That they just notified, and they added this new sector to their schedule. So if you want to improve the schedule, very easy. If you make it worse, to withdraw commitments, very complicated. Doable, but complicated. And it's more or less the same approach in all trade agreements. And for goods, you have a similar type of mechanism. So if you want to change a tariff line that was bound, it's a similar type of approach. So it's not really something special for services. Another important thing to keep in mind, and we'll see that in a more practical way when we look at your schedules this afternoon. Keep in mind the relationship, but also the difference between MFN exemption list, and your schedule of commitments. Okay? Your schedule of commitments, so you take commitments on market access and national treatment. And these are the minimum guarantees on market access, national treatment you give to all other PACE Plus parties or to all WTO members. Okay? Each of the others is entitled to everything that is in your schedule. Okay? So your MFN exemptions, where you reserve the right to give a preference to somebody, to another PACE Plus parties or to another country, you want to give them a preference, you're allowed to do that by having an MFN exemption. So we saw the exemption of road transport, they give a preference to some countries. You're allowed to do that, but it cannot go against your specific commitment. Okay? So if you give a preference, it needs to be a preference that is above your commitment. For example, if you have in your schedule 49% foreign equity in telecommunications, that's your limitation. You've put that in your commitment on telecom, maximum foreign equity limit of 49% in telecom. This is the minimum you have to give to all other parties. Okay? If you have a MFN exemption that allows you to give a preference to one other party, actually we don't need to follow that specifically, but if you want to give a preference in telecom to one party, you're allowed to do that because you have an MFN exemption. You can give to one other party up to 60% or up to 70%, but you still have to give everybody up to 49. That cannot change. So you cannot say, oh, I will give 49 to one and the others get only 30. No. Everybody needs to get the minimum that is inscribed in your schedule. Okay? So keep that in mind. Your MFN exemptions cannot change, the minimum level that you guarantee to everybody through your schedule of specific commitments. Okay? The important thing to keep in mind is there's always a little bit of confusion with respect to that. Is keep in mind that MFN applies in principle across all sectors. So it doesn't matter, the sectors that are listed in your schedule. MFN applies also to sectors not listed in your schedule of specific commitment. So for example, if in your schedule of commitment, you don't have hotels, you don't have hotel services, okay, MFN still applies. So that you still need to give foreigners the same treatment in hotel services, even if you don't have commitments. The same treatment, it can all be, the market can be closed for foreigners or not, but the same treatment. Yeah. Okay, to conclude, as I said, we saw market access, we saw what is national treatment. This is what needs to go in the schedule. Okay, but there are many, many other measures of governments. Most measures of governments are not market access, they're not national treatment measures, and all of these measures are not affected by your schedule, not affected by your commitment. You're free to change, introduce, modify these laws and regulations as you wish. Okay, and countries do that all the time. So most measures are not affected, they're not covered by specific commitments. All non-discriminatory measures of governments that are not market access, all standards, licensing requirements, all kinds of procedures, if they're non-discriminatory, that's not affected by commitments. It's not something you need to put in your schedule, and what you have in your schedule has no bearing on all these types of measures. Okay? Government procurement is not affected by your schedule. So government, market access, national treatment, MFN do not apply to government procurement. It does not apply to subsidies in PESA+. We're not concerned in principle by export-related measures. Schedule is more about, imports, the access that you give to foreign suppliers that want to come in. And private commercial actions in principle are not affected by commitments in the schedule. Why are private commercial actions not relevant, not affected in principle? So if you have a company in your country that decides to only buy certain services from the local companies, they don't want to have to import services from abroad, a private company, why is that not affected by your schedule of commitment? As a trade official, do you need to do anything about that? Why is that not affected by specific commitments? Think about what we discussed yesterday. Private commercial actions. Think about the scope of the agreement, what the agreement applies to, what does it apply to? We're going to redo the test we did yesterday to see if we have the same winner as we had yesterday. So is that something that is you need to worry about, that is affected by your schedule of commitments? What does the agreement cover? What is the scope of the agreement? Article 1 of the agreement. The agreement cover, Article 1 of the GATS and I think Article 2 of PESA+ chapter. The agreement covers what? 4 modes, yes, but aside from that. Measures of governments at all levels of governments that affect trade and services. This is what the agreement or the chapter applies to. So it applies to measures of governments. So this is the focus of the obligations applied to governments, to measures of governments. They don't apply to, in principle, to measures of, private commercial actors. So if some companies can decide who they want to buy their services from, they can discriminate if they want, but the obligations focus on measures of governments. That's the scope. So that is not affected by your schedule. And just to summarize again, commitments, I think I've said that more than once or twice, guarantee minimum levels of market access national treatment that you give to each other party in PESA+ or each other WTO member. You are always free, that's important. You're always free, thankfully, to offer better conditions of access or treatment than what is in your schedule. So what is inscribed in your schedule, it doesn't mean you have to apply these measures. It doesn't mean you need to apply those limitations. These are minimum level of access that you guarantee to others. You cannot be more restrictive than that. Okay? But you can always be more open. So it's not because you have in your schedule a 49% foreign equity limit that you necessarily need to apply that. You don't have to. Okay? You can have a more open regime than what is mentioned in your schedule, and that's very often the case. Okay? Because you have many sectors that are not listed, that you don't have commitments on. It doesn't mean that these sectors are closed. Often they are open. Foreigners can come, but there is no guarantee of access. You have no certainty. Governments has not bound itself to not impose market access limitation or national treatment limitations. Okay? So you're always free to offer better conditions of access and treatment than what is in your schedule. Okay? And as I said, you can actually improve your schedule in a very easy manner. It doesn't require compensation or anything like that. Okay? So we'll come back to this little test later. I think we can move to our connected presenter next. Okay? Thank you. So keep that in mind. Keep that as this presentation as a reference. All these things that is discussed as part of this presentation is not something that I'm just invent or say because I like to say that. It actually comes from another document you have on your list of background documents. It's the scheduling guidelines that WTO members have developed in the Uruguay round negotiations. So they have actually, inscribed guidelines on how to read and understand schedules. So all these principles, what you need to fill out, what none means, what unbound means, that's all, detailed in this document, which is, 10, 15 pages of text. So keep that in mind. Keep the presentation in mind. This afternoon, we'll try to apply all that to look at your schedules, and we'll ask you questions on your schedules, and you can ask us questions on your schedule. Okay? Good. Thank you. Thank you, Thomas. Thank you, Thomas.